Welcome to this week's episode of our Case of the Week series, brought to you by eDiscovery Assistant in partnership with 𝐄𝐥𝐬𝐧. My name is Kelly Twigger. I am the founder and CEO at eDiscovery Assistant and the principal at ESI Attorneys. eDiscovery Assistant is a platform that helps lawyers and legal professionals manage the power of ESI as evidence by reimagining the way we conduct legal research and training for eDiscovery. Each week here on our Case of the Week series, I choose a recent decision in eDiscovery and talk to you about the practical implications of that judge's ruling, what it means for you, your practice, and for your clients, and how to do the discovery of ESI better. Unlike any other substantive area in the law, the constantly evolving landscape of technology means that trial courts on both the federal and state level are regularly issuing new opinions on parties' obligations around ESI. Because the bulk of our learning in eDiscovery comes through case law, diving into the details of those decisions and what our practical takeaways are is one of the best ways to understand the issues and details we need to focus on in planning and executing in eDiscovery. All right, with that said, let's dive into this week's decision. You'll find a link to the case that we're discussing today in either the post or the comments, depending on whether you're viewing us on LinkedIn, YouTube, Facebook, or Twitter. You'll also find a link to our partner eDiscovery Today's post that Doug Austin put up a couple of weeks ago on this particular decision as well. This week's decision comes to us from the Owen versus Elastos Foundation case. This is a decision from March 16th of 2023, issued by United States Judge Barbara Moses. Judge Moses is quite prolific in terms of discovery issues. She's in the Southern District of New York, and this is the 71st decision from Judge Moses in our database. So she's one of the more prolific judges in terms of discovery decisions. A lot to take in, lots of thoughtful deliberation from Judge Moses. As always, we tag each of the decisions in our case law database with our proprietary issue tagging structure, and this week's issues include possession, custody, and control, and cloud computing. Now, we are before the court here on a motion to compel the review, collection, and production of responsive data from the personal email account of Director Ben Lee of Elastos in discovery. Now, Director Lee lives and works in China, and he is an Elastos employee. It's director of operations and one of 3 members of its board of directors, but he is not a named defendant in the case. During discovery, Mr. Lee provided his laptop, phone, and personal WeChat account, which he conceded he uses for Elastos business and which he permitted the defendant's lawyers to collect and search. Mr. Elastos also searched and provided 13,000 documents from Mr. Lee's work email account, which is a Gmail-based account. Elastos asked Mr. Lee multiple times to allow them to search his personal Gmail account, but Mr. Lee refused. And the question before the court is whether Elastos has the requisite possession, custody, or control over Mr. Lee's personal Gmail account to require it to be searched for responsive materials. Evidence indicating that Mr. Lee has responsive information in his personal Gmail account is pretty scant here. And that's the crux of why we're looking at this decision today. So what is that evidence? On 2 occasions, Mr. Lee received emails concerning a personal investment at his elastos.org email address, and he forwarded them to his personal gmail.com email address. On one occasion, a separate occasion, he received an email concerning Elastos business at his gmail.com email address, which he forwarded to his elastos.org email address and responded to. And on 2 occasions, Mr. Lee participated in editing Elastos documents, one of which was a team budget and one of which was a white paper, using email addresses that were apparently generated by Google Sheets and Google Docs, respectively. That's the language from the court. That's not actually how Google Sheets and Google Docs work by generating email addresses. Someone has to physically input an email address for one of those to be shared with. That's all of the evidence that exists with regard to tying Mr. Lee's personal account to responsive information in discovery here. Now, when the plaintiffs realized that they did not have access to the spreadsheet from Google Sheets that was apparently generated by Google Sheets, they came to the court and argued that because those documents weren't produced, that they must be stored in his personal Gmail account. There's no other reason to suspect that other than the fact that they just don't have them, and that's the only account that they know of that Mr. Lee hasn't produced. There's no discussion of whether that information was available from another source, whether the other members of the board of directors had it, or whether it was provided to any other employees. The defendants, on the other hand, argued that the responding emails to both of those documents were in Mr. Lee's Elastos email account. And so there was no link to tie his personal Gmail account to those particular documents, meaning that the only piece of evidence that the plaintiffs had to create some sort of facade of responsiveness in his personal email account really does not exist. And that's all of the evidence that implicates Mr. Lee's personal email account. So how does the court look at this set of facts? Well, there are two issues before the court on this motion. First, whether Mr. Lee's personal email account is within the control of Elastos, as that term is used in Federal Rule of Civil Procedure 34, such that Elastos can be ordered to search and produce information from that account that might be responsive to discovery. The second issue is if that possession, custody, or control exists, whether the discovery sought would be proportional to the needs of the case under Rule 26 of the Federal Rules of Civil Procedure. Now, the court starts with the issue of control under Rule 34's requirement that a party may obtain discovery of documents in the responding party's possession, custody, or control. And the Second Circuit, where the Southern District of New York sits, follows the practical ability test, which states that documents are considered to be, quote, under a party's control when that party has the right, authority, or practical ability to obtain the documents from a non-party to the action, close quote. Now, among the factors that the courts consider are whether the corporation could discharge the individual for failure to cooperate in discovery, whether the individual has a duty under local law, which is going to be important, to turn over the documents on request, whether the corporate party previously secured the individual's cooperation in discovery, and whether the party has asked the non-party to turn over the documents at issue, and if so, whether the non-party is willing to do so. The court also notes that the burden of showing control rests with the party that is seeking the discovery, and in this case here, that's the plaintiffs. After discussing with you what the scant amount of evidence is that we have here, it's not really a surprise to find that the court says that the plaintiffs did not meet their burden here to show that Elastos has possession, custody, or control. The court hangs its analysis really on the fact that Mr. Lee works for Elastos in China. This court is not willing to assume that Elastos has the same practical ability to coerce compliance from Mr. Lee that a U.S. corporation would have with respect to documents in the physical or electronic possession of its officers, directors, or employees. Defendants, for their part, advise the court that, quote, Elastos has no policies that would give it control over data on the personal devices of its personnel, close quote. So the location of Mr. Lee is first and foremost primary because the law that governs Mr. Lee is not in the United States. It's actually in Singapore and China where he resides. The court then looks at what Mr. Lee has done to cooperate in discovery. And thus far, Mr. Lee has provided his laptop, he's provided his phone, he's provided access to his WeChat account, he sat for a deposition, and he prepared a declaration to the court when asked, detailing Elastos' efforts to search the company's Google, Dropbox, and Zoom accounts, as well as its dissemination of legal hold memos. Mr. Lee just really refused to allow Elastos to search his personal Gmail account despite multiple requests from Elastos. And as the plaintiffs provided no evidence as to the contrary, the court found that Elastos did not have the requisite control. The court then goes on to state that even if Elastos had control, there is little to no evidence that Mr. Lee used his personal email for business. The court distinguishes a case because he notes that where Mr. Lee used his work email for all work, including as a member of the board of directors, In other situations, board members often use their personal email accounts for corporate business. So the plaintiff cited a case in which other boards of directors are required to search their personal Gmail accounts, or personal email accounts, I should say. And the courts in those cases have required those boards of directors to do so. But often in those cases, those boards of directors do not have a business email account, or they simply don't use it. So it's a very different situation here, because Mr. Lee, as an employee, but also as a member of the board of directors, did use his Elastos email for all of his boards of directors related communications. So not the same situation, and really no additional attempt by the plaintiffs to draw any other correlations as to why Mr. Lee should be able to provide his personal Gmail account. The court does note in the footnote that if discovery reveals a valid justification for a search of the personal Gmail account, that the plaintiffs can renew their request. They just don't have enough evidence yet here. And I think that's pretty clear from the facts as we see them. There must be more that the plaintiffs had in bringing this motion, but it's not articulated in this decision, so it's difficult for us to know. With that reasoning, the court denied the plaintiff's request to have the defendant search Mr. Lee's personal email account. All right, what are our takeaways here? Well, this is not the first time that we've discussed possession, custody, or control in e-discovery issues on the case of the week. And it continues to be a crucial analysis in access to ESI. Here, the determining factor really appears to be that Mr. Lee resides and works in China, and the plaintiffs did not provide any basis under Singaporean or Chinese law on the control question, and the court was not willing to assume that Elastos has the same practical ability to coerce compliance from Mr. Lee that a U.S. corporation would have had with respect to the documents in the physical possession of its officers, directors, or employees. So that's an important distinction from a fact perspective. That's very interesting, though, because even though Elastos is subject to the discovery rules in the U.S., its employee overseas appears not to be. And I do wonder if this ruling will be used to prevent access to other personal sources of data from employees outside the U.S. Keep in mind, though, that the real reason for not requiring a search is that the evidence of whether Mr. Lee used his personal Gmail account was very thin. You need more to be able to get to personal sources of ESI. Where a party utilizes an email account that very clearly shows up in discovery as a method of communication of responsive information, you'll have to produce it. But the burden rests with the requesting party, and the plaintiffs here were not able to meet their burden with only a scant couple of references to the personal email account and the potential of this missing spreadsheet that was not provided in discovery. Make sure that you have the evidence you need to have under the existing court you're in to establish control under Rule 34, and links to the personal sources of ESI to allow for them to be searched. We'll keep an eye on this case to see whether any new evidence arises that requires the court to revisit this decision. That's our case of the week this week. Thanks so much for joining me. We'll be back again next week with another decision from our e-discovery assistant database. As always, if you have suggestions for a case to be covered on the case of the week, please drop me a line. If you'd like to receive the case of the week delivered to your inbox via our weekly newsletter, you can sign up at ediscoveryassistant.com/blog. If you're interested in doing a free trial of our case law and resource database, you can jump to ediscoveryassistant.com and sign up to get started. Thanks so much. Have a great week.